Hello everyone and welcome. My name is Dan Sampaio and I'm delighted to open today's Mondat webinar in association with Khaitan & Co, discussing recent changes in India's advertising laws and regulation. Your moderator for today's session is Samir Saar, who will introduce you to the panel. But before I hand over to them, a housekeeping item. You are able to submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible, but please do get in touch after the webinar for any additional information or if your question wasn't answered. It's now my pleasure to hand you over to Samir to begin. Thank you.
Ladies and gentlemen, my name is Samir Shah and I'm a partner in Khaitan's Corporate M&A Practice Group. I will be your moderator for today. Welcome to our webinar. Our topic for today's webinar is Are you ready for India's new advertising laws? And thank you for taking the time to be with us. On our next slide is the agenda for today's webinar. In summary, we will have a presentation from two partners of Khaitan & Company, specializing in advertising laws, followed by a panel discussion and then a Q&A session with audience questions. As Dan mentioned, please submit your questions using the facility provided in the webinar portal. If we cannot cover all questions during the webinar, we will respond offline by email after the webinar. We will also send a copy of the presentation and the recording afterwards. With that, I would like to take a moment to introduce our panel today. We have a wonderful panel which includes stakeholders in advertising who bring very different perspectives. First up, we have Mr. Subhash Kamath. Subhash is a very highly regarded veteran of the advertising industry. He has been a chief executive of leading advertising companies such as BBH and Publicis. Also, he recently retired as the chairman of the Advertising Standards Council of India. We also have with us Ms. Manisha Kapoor, who is at the forefront of advertising industry regulation, and she is the Secretary General and CEO of the Advertising Standards Council of India. Manisha also happens to be the Vice President of the International Council for Advertising Self-Regulation. We then have Mr. Rishi Gautam, who is the Global General Counsel of Tata Consumer Products. He is our third industry guest. Tata Consumer Products is a leading FMCG company in India, manufacturing and supplying consumer products not only in India, but in 200 countries worldwide. And it is a member of the famous Tata Group conglomerate. Finally, we have two partners from Khaitan & Company who specialize in advertising laws. The first is my partner Nishad Nadkarni, who is an intellectual property practitioner. He brings extensive advisory and litigation experience in advertising laws and comparative advertising disputes. Our second partner, Tanu Banerjee, is a TMT specialist with considerable expertise and experience advising on advertising regulations. So without further ado, I ask Nishad and Tanu to provide a brief presentation on advertising laws in India to provide context for our panel discussion. Over to you, Nishad and Tanu.
Thank you. Thank you, Samir. Can we have the next slide, please? And the next, please. Thank you. So a very good day to all our viewers. So Tanu and I will provide you brief insights on the self-regulatory mechanism, a gist of the various legislations that could be applicable, a background of the Consumer Protection Act, and some guidelines which have been framed in the context of advertisements. Can we have the next slide, please? So in India, there has been a dual regulatory regime when it comes to advertising. On one hand, there is self-regulatory mechanism, which is well developed and focused on advertising. And then there is a complex statutory framework. As regards the statutory framework, there has been no single all-encompassing statute for regulating advertisements. There have been various statutes which either relate to specific sectors or then relate to specific media. So whilst planning advertisements, it is essential to not only factor general regulations that apply to advertisements, but also provisions which are scattered in different product-specific statutes. As regards comparative advertising, the law has developed mostly through judicial precedents. Now let's first have a look at the self-regulatory regime. Can we have the next slide, please? So one of the most prevalent form of regulation of advertisements in India has been a strong self-regulatory regime. Can we change the slide, please? Which has been administered by the self-regulatory organization known as the Advertising Standards Council of India, also known as ASCI. This was formed in 1985. It's not a statutory body, nor is it a judicial body, but it's an independent organization. So ASCI over a period of time has developed an exhaustive code known as the ASCI code. This not only sets out the basic parameters relating to advertisements, but also guidelines for content of advertisements, such as disclaimers, mention of awards, use of children, depiction of gender stereotypes, and the do's and don'ts with regard to the same. Now, it contains sector-specific guidelines also for the automotive sector, the food and beverages sector, education, etc. Recently, it has come up with guidelines for endorsers and celebrities, and also for virtual digital assets, which are currently the rage. Now, Tanu will deal later with some of these guidelines. Now, most advertising agencies, manufacturers, service providers are members of ASCI, and consumers, consumer associations, or industry members can file complaints against any advertisement. Similarly, ASCI can also suo moto initiate complaints against objectionable advertisements. The code provides for an exhaustive mechanism to deal with these complaints. A preliminary period is provided for voluntarily complying with the anomalies with regard to the objections in the advertisement. Then there is a period for justifying the advertisement. If necessary, there is a technical experts panel which helps with technical claims. The complaint is then considered by a consumer complaints council, which comprises of industry specialists as well as professional advisors. Decisions or recommendations of ASCI are then given. These decisions are not judgments, but are normally respected and complied with by advertisers. The statistics suggest that 80% are normally complied with. Now, if you have an objection to the recommendation, there is an independent review panel, which is headed by a retired judge of the Bombay High Court. Now, since ASCI is not a judicial body, the recommendations or decisions do not have the force of enforceable judgments. But in case these are not complied with, ASCI from time to time also forwards these recommendations to the relevant regulators so that action may be taken if necessary. We will be discussing some nuances of this later. Can we have the next slide, please? Now, coming to the statutory framework, it is spread out in different statutes. These statutes do not per se relate to advertisements, but relate to regulation of specific products or services. Now, some provisions of these statutes relate to advertising also. More generally, the Indian Penal Code, which is the principal criminal law, maps out offenses and punishments for the same. It prohibits hurting of religious sentiments, obscenity, defamation, etc. The Information Technology Act, which is the primary legislation governing digital space, prohibits dissemination of any sexually explicit content that depicts children. When it comes to regulation relating to media, there is the Cable Television Act and the rules under that. These rules specifically require advertisements to comply with the ASCI code. Speaking of specific products, there is the Cigarettes and Tobacco Products Prohibition of Advertising Act, which prohibits advertising of tobacco. For drugs and cosmetics, there's the Drugs and Cosmetics Act and the Drugs and Magical Remedies Act. Can we have the next slide, please? Now let's look at a statute which deals more specifically with advertisements, the Consumer Protection Act. It is now one of the principal statutes which governs and regulates advertisements. Earlier, the Consumer Protection Statute was relevant principally in the context of consumer disputes arising out of defective goods or deficiency in services, and these were tried before the Consumer Forum, which is constituted under the statute. The statute also sought to prevent unfair trade practices, which was broadly defined, though litigation in that space was not so much. In 2019, the statute was revamped substantially and several new aspects were introduced. The new act came into effect in July 2020. Now, with the revised statute, several changes were implemented into the construct of the Consumer Protection Act, which now provides also for the basic framework for advertising basic regulation. Now, two significant aspects introduced into the statute, which we would be discussing today, would be the introduction of the concept of misleading advertisements and the formation of the Consumer Protection Authority, the Central Consumer Protection Authority, to regulate advertising. The Act also introduces penalties and punishments, including an imprisonment up to 5 years for issuing misleading advertisements. We would be discussing the impact of these later in the session as well. The Consumer Protection Authority, better known as the CCPA, has been formed to regulate matters relating to consumer interest, unfair trade practice, and also false or misleading advertisements. Now, the authority is located in Delhi and has very wide powers. It can initiate proceedings suo motu or on the basis of complaints. It can investigate acts which affect consumer interest, or then refer such matters for investigation to specific regulators or the consumer court. It also has the ability to undertake research in respect of consumer protection and also undertake activities to spread awareness. And yes, it also has the power to frame and issue regulations to protect consumer interest. I'll pass the handle now to Tanu to deal with some of these recent guidelines and few sector-specific guidelines. Over to you, Tanu.
Good evening to everyone who's joined us today. Now, just as Nishad explained, amongst the various powers that the Central Consumer Protection Authority has under the Consumer Protection Act, it also has the power to issue guidelines to prevent misleading advertising and protect consumer interest. Basis these powers, earlier this year, it issued the guidelines for prevention of misleading advertising and endorsements. Since these have been issued under an existing statute, which is the Consumer Protection Act, which enables CCPA to issue such guidelines, even though they are called guidelines as opposed to rules or regulations, they actually have statutory force in India. We'll talk a little about what these apply to all advertisements regardless of form, format, or medium, and not only to advertisers, but also to advertising agencies or endorsers who are helping create ads. They lay down a broad regulatory framework for advertising, including what does not constitute misleading advertisements. Essentially, it says that ads should contain honest representations and should not exaggerate a product or a service. And they shouldn't also downplay the risks involved in a particular product or a service. There are also some principles to regulate bait advertisements and free claim advertisements. Now, bait advertisements are those where products are offered at a low cost as a bait to consumers, and free claim advertisements are those where free products or features are offered. The guidelines say that if such ads are published, then manufacturers must ensure that the products are actually available as advertised. And once a demand for this product is created basis the ad, the manufacturer should be able to actually meet the demand as well. We'll next talk about surrogate advertisements, which is a significant concept under the guidelines. Surrogate advertising basically means indirect advertisements of prohibited products. These could be alcohol, tobacco, cigarettes, etc. Although the brand that is used for these prohibited products can be used for other products which are not in the prohibited sector, so long as the guidelines are not violated. This concept is often referred to as brand extension as well. For example, many alcohol companies, while they can't advertise alcohol directly, but they use brands on merchandise like caps, or beer mugs or stationery, etc., which helps them to increase the visibility of the brand. In fact, there are parameters that need to be met while selling such brand extension products as well. Next, the guidelines also speak about the responsibilities of endorsers and celebrities. We'll talk about this a little more in detail in the next slide. Use of children in advertisements in ways that would encourage dangerous behavior or which could improperly impact them is prohibited entirely. Other than that, we would have noticed that often ads contain different sort of disclaimers. So in respect of disclaimers, the guidelines specify some rules on language, font, placement, etc. of the disclaimers into the ads. If you could please move to the next slide. Now, from what we've discussed so far, you would have gathered that advertising regulations in India are spread across various legislations and regulations and are administered by two parallel bodies, one being ASCI, which is a voluntary organization, and the other being the CCPA, which is a statutory body. An added layer to this is that apart from the framework of ASCI and Consumer Protection Act, there are also some sector-specific mandates, which are again spread across guidelines, advisories, and legislations issued by different regulatory bodies in India. Of course, it's difficult for us to cover all sectors in this session, but we will try and cover three sectors which have grown massively in India in recent times, and therefore from a market perspective are quite relevant at present. First, here we'll talk about the framework on influencer advertising or celebrity-led advertising. These are relevant for influencers themselves, but also for advertisers engaging the celebrity or the influencer to endorse their product or service. Endorsements in general are governed by both the consumer protection regime and also the ASCI guidelines. Both of these regimes have overlapping provisions. Essentially, they require that there should be disclosures of any material connection between the advertiser and the endorser. Effectively, it means that ads that are created by influencers should be tagged as sponsored or paid promotions, or some similar disclosure in this regard. Secondly, the endorser should have undertaken some due diligence by itself on the product or the service that they are promoting. Now, obviously, this overall puts significant onus on the endorser itself in terms of promotional posts and ads, but also on the advertiser to make sure that the disclosures are appropriately placed. The second sector we'll talk about is the online gaming sector. Now, this is a favorite because the regulatory regime for gaming in India is as exciting as gaming itself. Gaming is a state-specific subject in India, which means that each Indian state can have its own laws to govern online gaming. And we have 29 states and all. Betting and gambling are illegal in most parts of India. This is because, as a general principle, any game that is purely based on chance is considered as gambling, and therefore it's illegal. And a game of skill, even if it is played with monetary stakes, is considered legal. For overall online gaming, ASCI had prescribed some guidelines. In effect, essentially, they require disclaimers to be added in ads for games where real money stakes are involved, or where there could be a financial risk to gamers. Now, other than the ASCI guidelines and the various state legislations on gaming, just a few months ago this year, the Ministry of Broadcasting in India also issued advisories restricting ads for online betting platforms across TV channels, digital platforms, and print media. Lastly, we'll talk about advertising of crypto products. Now, for a bit of background on cryptocurrencies in India, in 2018, the Reserve Bank of India, which is our central bank, prohibited Indian banks and financial sector entities from dealing with any entity that dealt with cryptocurrencies. Now, this prohibition practically banned cryptocurrencies in India, although in 2019, the Supreme Court of India overruled this ban. But of course, no one wanted to miss out on crypto investments just because the Indian government was skeptical. So people continue to invest in these assets, and cryptocurrency and NFT-based businesses continued growing in India. Considering this, ASCI published its guidelines for advertising on virtual digital assets and services. The guidelines require that ads of any cryptocurrency or NFT should carry a risk disclaimer, which essentially says that crypto products and NFTs are unregulated and can be highly risky. And there may be no regulatory recourse for any loss from such transactions. There are also some directions on the manner and placement of the disclaimer in ads across different mediums. The other point being that these ads should not guarantee any profits. and they should not draw any comparison to regulated financial products or assets. So as an overall takeaway from our discussion so far, in India, advertising regulations are spread across various regulatory and statutory regimes. And while ASCI and CCPA are two most prominent authorities administering the advertising industry, depending on the business or product of the advertiser or even the manner in which the ad is created, there could be other regulators and legislations to refer to as well. So for an advertiser, it's necessary to understand not only the framework under ASCI or the Consumer Protection Act, but in fact to also be advised on any other legislations that may apply. These could be legislations that apply to a specific product or even a specific business sector. With this, I'd like to wrap up our first segment for this session. Back to you, Sameer.
Thank you very much, Tanu and Nishad. That was a very crisp and thought-provoking presentation. And what an excellent segue into our next segment, which is the panel discussion. Let us give you a moment to grab your breath. Please grab a sip of water. I'll request all our panelists to put their cameras on. And Aaron, if I can request you to take the slide deck off. Excellent, thank you. So we're just lovely. So we have everybody. So like I said, why don't we give Tanu and Nishad a break? And perhaps Manisha, we could start with you. So just in terms of the ASCI code, I think Nishad gave a very quick overview, but you're really it. So if you can give us a sense on how does it practically work in terms of process, is it the advertisers who would take recourse? Would it be the consumers? Or how would that function? Tanu and Nishad, sorry, maybe your cameras can also come back on.
Yeah, hi Sameer. So essentially ASCI looks at 4 kinds of objectionable advertisements. So we look at misleading advertisements, which is also what the CCPA covers. But besides this, we also look at 3 other categories of objectionable ads. So we look at ads that could be indecent or vulgar. We look at ads that could be harmful, particularly to vulnerable population, like children. And we also have ads, so we also require ads to be fair in competition. So that's, another category of ads that we look at. So this is predominantly the code and, the way that our code is structured. And then, of course, as you mentioned, we have several category related guidelines as well that fall under one of these main chapters, kind of interpreting that chapter for different sectors. We receive complaints from the public. We can receive complaints from the government. We can receive complaints from advertisers or competitors or people from the industry. We can receive complaints from consumer bodies. So pretty much anyone can register a complaint with ASCI. It's free of cost for anyone that registers a complaint, and so that's what our membership funding kind of goes towards, is to set up this grievance system. Once a complaint comes in, as I think Nishad also briefly outlined, in some cases we just get a resolution immediately from the advertiser, but in some cases this needs to be investigated further, based on I think the criteria that kind of comes in, we take further action based on what's what the actual grievance is.
Understood. No, I think I grabbed 2 points from there, and maybe I'll circle back to you on one. You said that there's a little bit of an overlap. I think we should come back to that. But maybe if I go to Subhash. So Subhash, Nishad sort of outlined the process. I think Manisha gave us further depth. With this already there, was there really a need for the CCP? I mean, why this legislative intervention at all in the context of false and misleading advertising?
Yeah, I mean, if you look at any of the established markets across the world, whether it's the US, whether it's Europe or anywhere else, you realize that self-regulation works within the law, right? It works in partnership with the sector regulator in any of the established markets, right? We are a self-regulatory body, which means our members who have taken the pledge to follow a certain path and not to cross a certain line. right? However, being a self-regulatory body, it also means that in case of non-compliance, enforceability becomes an issue. With the sector regulator, who's the ultimate law in the country, enforcing it, then it gives teeth to any regulation that we may be talking about, right? Happily, and so is the case in India. We've been in very, very close touch with DOCA. We've been in very close touch with MIB and many other government divisions for precisely this reason, right? The first, I mean, being a creative industry, the first port of call has to be the self-regulator, because it is much faster. It is also educated by experts who understand creativity, what line should not be crossed, what is permissible, so on, what is creative exaggeration, but what is misleading, and so on and so forth, right? We can judge these things much faster than a court of law. And therefore, if there is, and happily, we've enjoyed almost 95-97% compliance from our members within 2 weeks of a complaint coming in. So that's a good place to be. But in cases where there is a non-compliance, or there is a misunderstanding, or a lack of understanding, which happens sometimes in very new age categories, then the best thing is to have your actual sector regulator as your partner, right? And that's the way we see it. I think it is very welcome that the Consumer Protection Act has become so active now, because it really gives marketeers something to think about. You have to be responsible, and I've always said this in all my interviews: with great creative power comes great responsibility. So when you want to go and create that imagery for your brand, there is a responsibility that lies on you and on your endorser, right? That you can't cross. And so as long as you're keeping that in mind, and wherever there is a extreme case of or a simple case of non-compliance, now we know whom to take it to.
Great. So maybe we take that Spider-Man analogy, and Manisha, I'll come back to you. So ASCII has a web, CCPA has a web. Where do these webs overlap? How do they intersect? What's your thought process?
Yeah, but we are the friendly neighborhood Spider-Man. Okay, we are the friendly neighborhood Spider-Man.
Yeah, so I think to the extent that both of us are looking at misleading ads, I think that's really where the overlap is. As you mentioned, CCPA and the consumer authorities and the Consumer Protection Act, advertising is only one part of it. There are several other ways in which they look at consumer protection. So it's in that sense a larger mandate, which includes product deficiencies, service deficiencies, a lot of other issues surrounding consumer protection. ASCII's remit is sharply focused on advertising. And we look at, like I mentioned, advertising that goes beyond misleading ads, though that does form a bulk of what we look at. But we look at objections of other kinds as well. Other thing to remember is, again, I think as Subhash mentioned, both regulation and self-regulation have complementary roles. Being the first port of call, things to remember is that self-regulation does not cost the taxpayer anything. Okay, it is a quick mechanism of grievance handling which is fixed by the industry. Our complaints are sorted out in days and weeks where the consumer gets a resolution. So I think those become some of the advantages of self-regulation. We are much more agile. You've seen self-regulatory guidelines that we've brought in for crypto, for gaming, for influencers. Pretty much as these categories emerge and evolve in the market. So, the code can be much more agile and responsive to market conditions. We've just released a report today on dark patterns and, how that protects consumers and what are the challenges and vulnerabilities over there. So I think there are advantages to self-regulation, which is low cost, speedy, agile, responsive, up to date. Those become the advantages. ASCII also has the advantage of, as you mentioned, being a part of the Cable TV Act, and therefore also has, a kind of legal backing on certain platforms. Our compliance rate, just the voluntary compliance rate, is extremely high. And I think even globally, advertising self-regulation is one of the most successful forms of self-regulation. The law, of course, comes in with, the enforcement ability. And I think that provides a great context and a great incentive for people to regulate themselves. So I think that works in very complementary ways. As Subhash said, we are in constant touch with the Ministry of Consumer Affairs, with the Ministry of Information and Broadcasting on issues that are of concern for both of us. I mean, the agenda is there's a big overlap in the agenda, and so we kind of work pretty closely with the government on certain matters.
Great. So I think let's move from the regulator to the regulated. I mean, Rishi has been very patiently waiting. So Rishi, love to hear your perspectives on how are advertisers like yourselves coping with these changes. And I mean, the operative word is risk. How do you manage the risks in relation to false and misleading advertising as an advertiser?
Okay, hi everyone. So before I start, I must say, I mean, we as industry endorse everything what Manisha has said. And if I may add, this new regulation is in place, the new regulator is there. All that we are expecting is that this amazing, if I may use the word jurisprudence, that ASCI has developed and evolved over the years, if the regulator sort of takes cognizance of this, again, I would use the word jurisprudence, and bear with me here, it's entire sort of the thought process, the thinking, the agility, the fact that we as members of ASCI have always sort of so how it works for us is that we have a system in place, fine-tuned over a number of years. We are food and beverages, so we are also regulated by our sector regulator. And very often the situation is that a claim the claim is probably being prosecuted by the sector regulator as well, and ASCI also looks at it. So we have evolved this framework. We have a matrix for escalation within the organization, and we do provide that kind of training. And when these new regulations came, one of the fears that we had was, are we going to start with scratch, or is the sector regulator going to rely upon what has already been developed? So my request, I mean, I don't know whom I'm requesting to, but my request is if the sector regulator sort of works more closely with ASCI, understands their thought process, learns from their experiences, it will sort of, what it does is that for industry, people who play by the rules, people who are willing to play by the rules, it makes life easier for us, as well as sort of picks up the, if I may use the word, the rotten apples faster. So far, we have not had any experience with under the new rules. The new authority have had no brush with them. But look, again, as I would say, we have, again, the example that she gave was this sort of dark patterns. So things like those, it will take time for the regulator to catch up to those practices, then the rules to come out. But what ASCI does very brilliantly is evolves the thought process, gets the industry consensus, looks after the interests of the stakeholders and the consumers, and gives a solution which is already in place. So we are quite sort of hopeful that the regulator will look at what is there already and sort of complement their role rather than having a divergent path.
Loud and clear, Rishi, and whoever hasn't heard it, we'll ensure your voice travels to them. So leave that with us. I think that's one for us to take care of. So maybe why don't we do this? So we've heard the regulator and the regulated perspective. Tanu, how about we get into a little bit of detail? So you spoke about these CCPA guidelines. Drill it down a little bit. What is really this misleading advertising concept, and when does an advertisement actually become misleading under the new rules?
Yeah, so Samir, really, just the way it sounds, anything which is falsely describing a product. So, any ad that is inaccurately describing a product or a service, or let's say it gives a false guarantee of the ability or functionality of the product, or let's say it's deliberately concealing, something which is important for the consumer to know. All of these things can become misleading ads in that sense. So let's say what can be deemed as misleading. The fundamental principle is that the ad should basically be an honest and truthful representation of the product or the service that's being advertised. And I must add here that the Consumer Protection Act, in fact, places quite a high threshold of diligence on advertisers on this account. So it doesn't take into account the intent with which the ad has been created. The fundamental principle is that the representation in the ad should be not misleading and it should be accurate to the product. Other things like it should not exaggerate the functionality, it should not exaggerate the benefits. It should be based on, let's say there are some claims in the advertisement. We will see several ads use superlative expressions for the product or the service, saying that, okay, this is best of so and so in the market, etc. So these sort of claims should be basically backed by some research, backed scientifically. And then lastly, of course, if the product is in a certain sector and that sector has, guidelines or laws to comply with, then your advertisement should also be aligned to that. That's the summary of it. But of course, these are detailed points, and every ad in that sense, every advertiser should take some diligence that, they are within the guidelines. And I think the consumer protection regime and the CCPA guidelines that have come in, they're quite helpful in that sense. So just some reference to that would also give a fair bit of indication to an advertiser.
Great. Sorry, I was furiously typing away because the number of questions are unmanageable. Aaron and I are having to work through those. But nonetheless, I will hang on to the word diligence. It's given me an idea for a question that I go back to Manisha with. But before that, I was scribbling some notes, and Nishad, it'll be helpful to get your perspective. So Tanu's just explained where misleading advertisements are heading. Is this something which is open to a class action, or should it only under the CPA, or will it only be open to individual complaints?
Yeah, so this is a very good question, I think. When you are speaking of the Consumer Protection Act, even prior to the amendment, complainants were defined quite broadly under the Consumer Protection Act. Now, this definition not only includes individual consumers, but also a set of consumers having a common interest, or for that matter, consumer associations. So class actions, as we understand them to be, in the sense that where a set of people have a common interest vis-a-vis a common defendant, so to say. Would these be identified by the statute and encompassed in the statute? The answer is yes. Now, insofar as misleading advertisements are concerned, as I indicated to you, that's a slightly more recent introduction into the statute, right? And until now, the class actions have been tested in the context of defective goods, deficiency in services, and those kind of traditional consumer disputes. So just to give you an example, when you talk about a builder selling houses, there are a class of purchasers within the same premise, right? And if there are false representations made in the course of rendering the services of the real estate service, then these buyers have come together and initiated action before the consumer forum. There has been litigation around it as to the maintainability of the statute, and there has been a National Consumer Court decision and a Supreme Court decision which indicated that these class actions are maintainable. In the context of the CCPA and misleading advertisements, however, it's not yet tested. But I have no reason to believe why these actions should not be maintainable, and why they should not be actioned by either the courts or the CCPA. And of course, in terms of what can be the result of such actions, they would be very similar to what it would be for normal consumer actions. So there would be a direction to remove any objectionable claims, rectify those claims, or maybe just take down the advertisement. And then, of course, you have the penal remedies and in terms of penalties and imprisonment also, which have now been introduced for repeat offenses or the first offense as well. So that would really depend upon the nature of the advertisement, the nature of the claim, etc.
So maybe we just go back to Tanu, and Tanu, perhaps you can pick up from where Nishad left off. can you give our audience a sense of what are the financial penalties or fines under the CCPA? And are they meaningful enough to cause a dent, or will it just be something that is brushed off and forgotten?
Yeah, very interesting question again, Samir. So I think I'll start with saying that, look, CCPA, we discussed that it's a statutory body now, and it's not as if it's not being taken seriously. The industry is taking it seriously. And I think Subhash, very rightly mentioned that generally a self-regulatory regime also works within a framework. And, that framework comes with CCPA as a statutory body. So one is that, of course, it's a serious sort of industry body. In terms of specific fines and penalties, there could be monetary fines and there could also be imprisonment. Now, fines range between 10 lakhs to 50 lakhs rupees, which could be roughly around I think $12,000 to $60,000 at the outer side, which in some sense may not be very substantial. But I think the deterrent is that there is also, the Act also prescribes imprisonment. Typically, we've not seen sentencing in these sort of matters, but then there is a provision for that, and that can't be ignored. So I think that's point number one. The other is again for endorsers, for example, this was for advertisers, but endorsers, there's a different sort of penalty. They could be barred for endorsing for a period of time. And I think if you look at it from an endorser's perspective, brand endorsements are one of the most lucrative opportunities for them. So to be barred altogether from endorsing is quite a deterrent, even if the financial penalties are not substantial. So that's second. And I think overall, I'll wrap it up with saying that whatever the financial penalties may be for an advertiser or a huge corporate, or even a let's say a really big celebrity or a star, it's possible that they could afford the financial penalties, and it's possible to say that it's not substantial. But imagine the reputational dent that it will cause, right? And I think that for especially in the context of branding, right? I think that is a bigger deterrent than really just financial penalties. So the way to look at it is, yes, there is provisions for adequate fines, imprisonment, and other remedies. But any advertiser or endorser in this space would definitely be very concerned about the reputational risk that it could cause to the brand.
So we have an advertiser in the room, and before I go back to him, Nishad, can you help us just assess, under the CCPA, has some action already happened? Do we have precedents available, or is it all still raw and untested?
Sorry, wasn't me. Yeah, so the CCPA is a new introduction, yes. It's just been introduced during the course of the pandemic, so to say. And yes, it has been very active. There's been a good amount of action which has been taken. CCPA has been issuing a lot of notices, suo moto. Many of them, as you would guess, were in the context of claims which were related to the COVID pandemic. And it was not only, so since medicines are not really capable of being advertised, the question is, what were these claims in respect of? So these claims were in respect of almost anything that you could purchase. They could be air conditioners, which filter air so as to reduce the virus in content in the air, or it could be plywood with coatings which would prevent the infection of COVID, or which would kill the virus, etc. So a lot of these manufacturers have been issued notices in the course of the life of the CCPA so far. CCPA has, in certain cases, imposed fines. In certain cases, the advertisers themselves have withdrawn the advertisements. In certain cases, there have been a modification of claims or a restriction of the claim, and those advertisements have continued. More recently, moving slightly away from the COVID pandemic, there was a FMCG brand which was pulled up with regard to certain claims which were made with respect to a product. I will not go into the details of the product, etc. But ultimately, the discontinuation of the advertisement was called upon. Another complaint which I recollect is in relation to a telemarketing and e-commerce website with regard to misleading of consumers regarding information on inventory and production of goods. I think a fine of about 10 lakh rupees was imposed. As regards the procedure is still a little fluid. There are no fixed formats for complaints or responses, etc. Similar to the ASCII, where legal representation is not permitted, it is not clear yet whether lawyers can present the cases before CCPA. We've seen both things happen. Certain members permit legal representation, certain members permit accompaniment by legal representatives, but the companies have to make the representation before the CCPA. They may be assisted by external lawyers. So that's the not so brief answer to that.
Understood. So good. I don't think the idea is to scare our audience. So I guess Rishi, I need your help. Both Tanu and Nishad have obviously made it clear that the new guidelines have teeth. Those teeth, the animal bites, and the bite can be a little dangerous. So just from your perspective, again, as an advertiser, what is it that you'd like, for example, to be clarified, either in relation to the new legislation or in relation to ASCI? What is your wish list?
Absolutely. There are a few things I think Tanu has already hinted towards. There is requirement of clarity. But before I move on to those, I would just like to add to what Tanu was talking about in terms of whether reputational damage is sufficient. So for some advertisers, especially large listed organizations, increasingly it's now a statutory requirement for especially global corporations about our ESG responsibility. And as far as I am concerned, I view yes, there is an advertisement sort of thing going on parallelly. My marketing people and the business side takes care of it. But for me, a notice from ASCII, a notice from FSSAI, pulling us up for an advertisement which can be viewed as we not fulfilling our ESG requirements, especially towards children, nutrition, social responsibility, gender stereotyping, I would take it quite seriously. So more than just a financial sort of a thing, or even the risk of imprisonment, it is the ESG linkage which for at least for some of us is becoming increasingly important. Our reputations, matter a lot there. But coming back to your question, as you have already mentioned, for some of us, like in FMCG sector, we have a sector regulator, we have consumer protection, FSSAI, we have the consumer protection guidelines. We are already subject to ASCII as a member. So I think at some stage, a consolidation is what people should, I don't know who, maybe it's a thing, it's an ongoing process which we should think about, but a consolidation of, so that at least there is clarity in terms of who governs what aspect and sort of makes it more streamlined. I'm not saying that it is not streamlined. I know ASCII will not look at matters which are already subject to FSSAI and those sorts of things, but even within FSSAI and the new regulator, I think the jurisprudence will evolve on that. Similarly, more clarity required. There's more clarity requirement on targeted advertisements. Tanu had briefly mentioned about brand extensions. I can already see a question coming on brand extension and surrogates, not from alcohol sector, but from pharma sector. I think you should probably answer that. And yes, gaming, other sort of cryptocurrencies, new age businesses. The time is that we need clarity on each one of these things.
I think that's a good list. I've been making notes, and we'll obviously pick up on this, but I still haven't forgotten the words due diligence. And Manisha, I think we need your help here just to, so we now know what the advertisers want. But the question really is, how do they avoid a rap on the knuckles? And And as Rishi has put it, there'll be a lot of your members who will be holier than thou, who will not want even the slightest of slippages to take place. What's the kind of due diligence or compliance which they can preemptively take to prevent any of their advertisements being treated as false or misleading? What's the catch there?
Yeah, so I think as a self-regulatory organization, while we are very established, I think on the corrective action that we take, on ads that may be in potential violation of our code, I think one of the big agendas we also have is how do we help the industry get it right? So it's not just about being the cop on the other side of the signal and waiting for you to break the signal, but how do we also educate you about traffic rules and help you understand the importance of it, or support you in that understanding. So we have a couple of services that we offer. One is exactly as you mentioned, due diligence that can be done by advertisers, including testing of technical claims, and this can be done at a pre-production stage, so at a script stage or a storyboard stage, and that I think will allow advertisers to be more confident that someone has kind of taken a look and flagged off if there are any concerns that could be addressed during the production stage. We also offer a similar service for endorsers, where endorsers can do this similar due diligence, and as you would know, under the law, if the endorser has done their due diligence, if they can demonstrate that, then these penalties would be waived off. So that's again something that the law provides for. So again, endorsers are doing due diligence and providing that evidence becomes a crucial service also that we provide. Besides this, we also have training programs that we offer to corporates, so that increasingly we want self-regulation to work not just post publication, but at the point of creation, and that's important, that it's not just the legal teams who have to defend these ads eventually, but a marketer or a creative person who's making this ad in the first place has a sense of what these regulations are, and how can we kind of go about preventing some of these things happening. So I think those are the issues that increasingly we are working on.
Understood. So maybe if I come to Subhash, and Subhash, we'd love to hear your perspectives. So we have Rishi's perspective, but more from a broader industry perspective, what are you hearing, particularly with brands and advertisers? How are they coping with these changes? And the changes are coming thick and fast, that whether in the ASCI ecosystem or in the CCPA ecosystem.
Yeah, well, there are quite a few new things that are emerging, right? I mean, CCPA is relatively very new, and therefore there are a lot of questions, even in the advertising industry, being asked about, okay, so how do we navigate this? What do we keep in mind? And so on and so forth, right? In some of the more established categories, I would say things are much easier understood. In some of the new emerging categories, there are a lot of questions because the law itself is not clear, like NFTs and digital assets. There is no specific, and questions are being asked by the consumer, questions are being asked by the advertising industry. So some of those questions will continue. And as Rishi said, look, hopefully there'll be clarity as we go forward with more conversations. Hopefully there'll be streamlining of processes. But so far, luckily, we haven't seen any confusion yet. Because as Manisha had pointed out, there is a tremendous overlap between the CCPA guidelines and the ASCI guidelines, which were always there, right? And we will continue to issue sector-specific guidelines as they come along, right? Till a few years back, the gaming industry was not something that necessarily came up, but we had to do it because it's become a pretty big industry. Influencer marketing is growing quantum fold every year, right? And in the digital medium, what is an ad and what is content, the lines are getting blurred. While on television, you never had that problem, right? In the digital world, you can put up an ad and take it off in 2 hours. So even before a complaint can be registered, that ad has changed. So there is a lot of challenges with newer mediums, newer platforms coming up, and therefore it is extremely important that, as ASCII, we are not just policing the narrative, but also helping shape the narrative. And that's what I think Manisha was referring to in terms of the training programs that we're conducting, in terms of the guidelines that we're issuing. Hopefully, it won't lead to confusion, because there are two authorities that one has to navigate through, because like I said, the laws are common. Even the ASCII guidelines are within the law, right? However, the CCPA has done is to bring in a higher sense of enforcement and penalty, right? Which perhaps was not there, even for endorsers and celebrities, for them suddenly, oh my God, okay, let me just protect myself from this one now. Earlier, they used to say, look, I'm just a paid actor, so I don't need to worry about the claims. That's the brand person's problem. They just say, no, you are accountable, because you have millions of followers believing what you say. And if you are going to be the endorser of that brand, then sorry, you are also equally accountable. So these were conversations that have emerged deep.
Sure, but maybe if we just stick to what you just said about endorsers and celebrities and so on, and there's in fact a bunch of pre-registration questions that we receive, so I'll try and plug those in as well. There's a question on fairness. Is it really fair to hold endorsers and celebrities accountable? I mean, why this entire focus? And let's assume if we are trying to go after recklessness, is the deterrent that Tanu explained, it sounds pretty serious to me, but to an endorser or a celebrity, to what extent will it really have that intended effect? Your thoughts?
I believe, look, India is a celebrity crazy country. Right? We are pretty crazy about our celebrities. We hero worship them, whether they are cricketers or whether they are film stars. We have even temples made for them. We are pretty hungry when it comes to having hero worship, our heroes out there, right? And therefore, when somebody I really hero worship comes and tells me that this product is pretty good, right? Recently, there was a case where a cricketer endorsed a real estate project which never materialized, and the people lost their money, and therefore, or they couldn't get their property on time. And therefore, you can't say that it's unfair. You have the power, you have the credibility with your followers, right? And therefore, you are accountable. So all the law says is, please do your due diligence before you go out there and endorse, whether on television or on digital or print or whatever, that buy this product because I say so. Then do your due diligence before you go and make that claim. I think that's basically what the problem is, right? The difference is that currently there is not too much of a distinguishing thing that we have asked for clarifications on that between a celebrity who might be paid 5.5 crores or 10 crores for a particular claim versus a digital influencer who might be getting 10,000 rupees to talk about a product. Right now, they're all called endorsers, right? And therefore the kind of penalties that might come their way should be in cognizance of the kind of earning that they might be having, right? So those are clarifications that are still going to happen. But yes, and even our influencer guidelines, for example, they are endorsers, right? All we are saying is, because the lines between organic content and paid partnership are blurring, your followers are there because they believe in, they have faith in, right? So if it is a paid for point that you're making, if it is a brand promoted point that you're making, transparently reveal that to your followers. Then let them make the choice of whether they want to buy the product or not, right? And the best part is when we went to actual influencers to ask their opinion on this, all the top influencers, I think this is great because it adds to our credibility and our authenticity. Right? It were many brands actually who didn't want the statement to be made. But I think in the long run, these are things which are extremely critical. And I think influencers going all the way up to top end celebrities need to understand their responsibility in this whole game. You can't just earn crores of rupees and sit back and say, look, I'm just a paid actor.
Sure. I think the word digital is something which we do need to focus on as a part of the panel, and maybe I have one for Manisha and one for Rishi, and then I can tell we're borderline on time, so we'll flip to the Q&A. But Manisha, how has this entire digital advertising situation impacted the role of ASCII, and how is ASCII dealing with that entire challenge?
Yeah, so I think it's, digital is a challenge for all regulators and self-regulators globally because, the nature of advertising is changing. The nature of advertisers is changing because, earlier it's only people who had big budgets that could go on mainstream media and advertise. But, today you can pretty much advertise on your own handle. So just the sheer number of advertisers and the nature of those advertisers has changed dramatically. Campaign durations are measured in hours and days. So these are all kind of characteristics of digital that make any sort of monitoring, of them a very, very challenging job. And I think, so therefore we also turn to technology to kind of help us do this. So, we've deployed, now artificial intelligence based monitoring software. So we are also having to take the help of technology and become much more agile, much more real time, in the way that we monitor things, and therefore the use of technology to kind of help us navigate the digital space. Of course, having said that, I think from time to time we will have to prioritize certain areas because it's pretty much impossible to police the entire web and all the kind of content and ads that are going there. But yes, I think from time to time we assess what are emerging threats, what are big threats to consumer safety and to to consumers from an advertising point of view. And I think we will kind of focus on those sectors or on those platforms or on those formats that are big. So for example, when we did the influencer guidelines and even the whole investment in a software to track influencers, because that's now increasingly becoming a mainstream spend for advertisers. And also the consumer vulnerability is high there because influencers are much more trusted than, let's say, brands on their own handles. So that kind of creates additional vulnerability on from a consumer point of view. So so that made it a priority for us to kind of look at certain sectors. But yes, I think digital will continue to be a big focus for us. And I think digital also kind of brings us back to the earlier point that we were making, that policing will become demonstrative and symbolic. The real action needs to come in the good old preventive kind of space, and efforts on education, efforts on creating awareness, efforts on creating a culture of responsibility in the industry. Which alone I think in the long run is a more sustainable solution. Because as I mentioned, I mean, there is no entity anywhere in the world that can monitor the entire volume of advertising that's out there.
Perfect. Rishi, one last question on the panel, and then I want to flip to Q&A. So just on digital, and I think your sector is the most, I would say, the most direct and connected with the consumer. So for the FMCG sector, to what extent does digital advertising introduce a whole new world of changes?
Absolutely. Again, so direct to consumer, you would have heard D2C, and during lockdown, I think all of us have experienced these ads coming on personal care, new brands coming up in terms of food and coffee and those kind of things. Some of them have benefited immensely. So without needing too much capital, they can bring their product to the market, direct to the consumer. But that has a flip side as well. So especially in terms of personal care, influencers, pushing things in a manner which is not really, I mean, that would not, I mean, so the good thing is the compliance is easy now. ASCII has guidelines. The new consumer protection also has clear guidelines in terms of what to say, what not to say, the sort of quantity, quality. Comparative advertisement is again quite simple nowadays. Now, despite all of those, digital still throws a challenge because it's so easy to push a product through an influencer. I mean, very often we come across these Instagram, I mean, children sort of literally child influencers trying to push a product which, I mean, I don't know what to do, and it will be a challenge. And I'm quite pleased to hear what Manisha said. There are artificial intelligence sort of based software programs which will help in policing. I think this is a frontier which we all need to sort of watch the space, see how this gets regulated.
Understood. Okay, excellent. Thank you, everybody. I think that panel has gone well. We've gone through the topics we had thought we would like to cover. I'm conscious we don't have the entire scheduled time for Q&A, but there's been a buzz of Q&A, as we can all see. So, Aaron, if I can request you to pull the slide deck back. And maybe what I'll do is I'll start with, I will try and bundle a few questions so we cover as much ground as we can. And maybe Nishad, if I can come back to you. This is your pet peeve, which is comparative advertising. There are a couple of different questions on that. So for everything from pharmaceuticals to medical devices to the cola wars, people want to understand, when does comparative advertising become a problem, and what is really the thin line people are walking on?
Yes. So comparative advertising has normally been the subject matter of common law tort. Okay. There's not really been so much regulation vis-a-vis comparative advertising under statute. Though the Consumer Protection Act talks about the fact that you cannot disparage products, the rule is that you can compare products, no difficulty there. However, the thumb rule is that you must focus on your product, you must portray the features of your product, and what you should not do is show down another product. Now, comparison feature to feature is permitted. So, for example, when you are comparing two bulbs, for example, 5 lumens versus 8 lumens, fantastic. But his product is therefore bad, does not give you light, mine gives you light, not permissible. So, most often, these cases are decided on the facts of that case. There has been significant amount of litigation in the space of comparative advertising, and I've been fortunate enough to be a part of most of those, or I think all of those, before the Bombay High Court at least. And what the court also looks at often is, it looks at the advertisement not only in the context of one feature, but it looks at it holistically. It looks at what is the message that you are sending to the consumer, and what would an average consumer of normal intelligence perceive that advertisement to be? What is the message that is being given? So to answer the question in one simple sentence, comparative advertisement is permitted. You can probably puff your products. The claims that you make should be honest and truthful. You can puff it to a particular extent, to the extent that the consumer will understand that it is in fact puffing and will not take it to be an actual claim. Otherwise, it must be honest. And when you are comparing, do not show down the product of another. The moment you do that, you are going to be in trouble, whichever way you do it. It does not have to be spoken words. It can also be just innuendos or hand gestures saying, not good,
Perfect. No, I think that's very instructive. Maybe Rishi, just a question which perhaps you'd like to take, that when you're looking to engage a celebrity or an influencer or an endorser, what sort of comfort would you give them as a principle that all is well, hand on heart, all is well, please don't worry?
So we would again, we would not make the influencer sort of cross the line, and the objective is keep it simple, keep it personal. Like, what does the influencer personally feel about using our product, and leave it at that. Do not sort of go beyond what a common man would sort of behave in that particular manner. We've done quite a bit of that as well. We don't want to stretch it any more than what would be normal and reasonable in that story context.
I think that's perfect. I'll pick two last questions and I'll open them to Manisha, Subhash. Please pick them in whichever way you would like. So one is, there's a question from the digital advertising world. And they're saying, is it possible for the digital advertising companies to work together with ASCII, support them in guidelines and policy development? What's the kind of welcome mat over there for them?
Manisha, do you want to say this or do you want me to take it?
Yeah, go ahead, Subhash.
I think one of the things that Manisha and I both worked very hard over the last 2 years to establish is a very collaborative way of working. We have involved the industry, we have involved stakeholders in almost all our discussions, and before we came out with guidelines, right? For the influencer guidelines, for example, we got influencers, influencer management companies, client side, creative industry side, and civic society and people to talk about and give their inputs to us before we even drafted the guidelines. Right? So it's a very collaborative process. So very happy to hear if there are digital companies who want to come and have a conversation with ASCII and input into and brainstorm with us. And look, we are an industry body, so absolutely welcome anybody reaching out to us. We have done that now, even in the gaming industry business guidelines. We did that for the crypto. We're doing that for almost everything. We're making it very, very collaborative and welcome inputs from our industry partners. So specific to that point, digital companies, by all means, please come and join us. We'll create a think tank before we do anything, and you're welcome to join the think tank. Manisha?
Yeah, absolutely. So I mean, we would welcome the expertise of people who are working in the domain, both in terms of, the expertise, but also in terms of the practical, ways in which regulations can be implemented and monitored. So I think we would really welcome their comments and inputs.
Great. I think I've just received a note from the organizers. I think we're at the end of our webinar today. So I can just request Aaron to flip to the next slide, please. Or maybe we stick with the earlier one. Sorry, I just want to thank our panelists for sharing their experience and expertise with us today. It's really been a wonderful, wonderful webinar to discuss the changes to all of these new laws. And Subhash, Manisha, Rishi, thank you so very much. Without you, this webinar would just not have. I think an outstanding job to bring the industry perspectives to this discussion. And Nishad and Tanu, thanks to you are due as well for the absolutely slick presentation up top. And good luck with what lies ahead with these new regulations. And a special thanks to Mondac for partnering with us for this marquee event. And to our audience, I hope you found the webinar interesting and a worthwhile investment of your time. We certainly enjoyed bringing it to you. You will also separately receive a request for your feedback from the webinar. Please do take a minute to fill out the form and send us your feedback. Comments, criticism, compliments, everything is welcome. And please do not hesitate to contact us regarding any matters arising from this webinar. Our contact information is on the slide in front of you. Thank you for your attendance today, and we look forward to being of service again at future webinars. Thank you, everybody, and have a lovely evening ahead.
Thanks, everyone.
Thank you.
Thanks, everyone. Bye.
Bye-bye.
Thank you. Bye.